Hi, and welcome to the Medicaid Moment. I'm Katherine Jacobs, estate planning and elder law attorney with Warner Norcross and Judd. In these videos, we talk about the long-term care Medicaid programs in Michigan for older and disabled adults. Today, we're going to talk about durable powers of attorney in Medicaid, how they intersect, why you need one, what you should be looking for if you have one prepared or you're going to have one prepared, so that you are set up to make sure that the Medicaid process is as smooth as it can possibly be. So let's first talk about durable powers of attorney. They are generally part of an estate planning package, if you will, one of the estate planning documents. And I always define estate planning documents as emergency documents. Usually they come into play when there's an emergency. So with a durable power of attorney, the emergency is generally someone needs help or wants help with their finances, paying bills, talking to financial planners, selling assets, selling real estate, selling personal property, transferring motor vehicles, being able to sign deeds, being able to sign contracts. So anything that you would be able to do to manage your own finances or financial affairs are generally covered under a power of attorney. And so durable powers of attorney in Michigan can be effective. So, when can a person start acting for you? Generally under three circumstances. So a durable power of attorney can be effective immediately. So the minute it's signed, the person that you appoint can act on your behalf. So if we use our couple, Bob and Shirley, if they both execute powers of attorney that are effective immediately, once they're signed, if Shirley says, I'm appointing my husband Bob, Bob would be able to present that power of attorney, for example, to a place where Shirley has an IRA. An IRA is just going to be in Shirley's name, so Bob otherwise couldn't talk to someone about it or manage it or do anything with it. But under the power of attorney, if he's given authority under retirement accounts, then he could present that power of attorney to the entity that manages Shirley's account, be able to talk with them, be able to reallocate how it's invested, and make withdrawals if the power is given to him under that document. So that's effective immediately. A power of attorney can also be effective only when someone becomes incapacitated. So until such time that two doctors or a doctor and a licensed psychologist were to sign a certification saying that, for example, Bob was not able to manage his financial affairs, that document would not be effective. Now, just for context, powers of attorney are not one size fits all. So some people, it may make sense for them to have effective immediately. Others maybe only when they become incapacitated. That's something to think about. But I will tell you that sometimes you have to think about, what does that look like? How does one get determined to be incapacitated? How do those doctors sign off? And sometimes it does take a bit. It might take a few weeks or even a month or so to get that certification. Because, for example, if Bob, the family said, Bob's really struggling, we don't think he has capacity, and we need someone to be able to sign checks. He can't sign checks. He can't pay bills. We can't talk to different financial people, and we need to do that on his behalf. It may be that his doctor is going to say, well, I haven't seen Bob in 6 months. I can't just sign a certificate of incapacity. He's going to have to make an appointment, and that might take several weeks. So, especially with my older adult clients, I'm generally looking at, does it make sense for us to make this effective immediately? And depending on, the circumstances of other clients, does it make sense for us to only make this effective when and if someone is incapacitated? Now, that durable power of attorney that's only effective upon incapacity, we call that a springing power of attorney. And that means it springs into action when someone becomes incapacitated. And so that document might be fluid, and what I mean by that is that maybe, Bob and Shirley say only effective upon incapacity, and Bob has a stroke, and Bob is incapacitated. So that durable power of attorney is going to spring into action. And maybe over some time and rehab, Bob then regains capacity. then that durable power of attorney would no longer be effective. And so it can morph from effective to ineffective, or I should say not ineffective. And then the third way is sort of a hybrid. And oftentimes I'll see this with married couples where maybe they appoint one another to act immediately. But if anyone else is serving, they would have to be incapacitated. And so that is also an option. So if you have a durable power of attorney currently, I would suggest that you should know that. If someone sat down with you and said, is your durable power of attorney effective now, or is it effective upon incapacity, you should be able to answer that question. So take a look at it, read it, understand it. So then the next thing I want to talk about is the scope of the power of attorney. And I've looked at thousands of powers of attorney during my practice, and I will tell you that, we see a lot of recurring powers, but then there are different preferences, if you will, with attorneys and what they include, certainly different needs of clients. So not every power of attorney is the same, and they shouldn't be the same. They should be as unique as the individual client that they are being prepared for. But to that end, you should know what authority you're giving in a power of attorney, because it is that emergency document, and the emergency is I need help with managing my finances, and that power of attorney is going to tell us who's in charge, and the scope is going to tell us what they're allowed to do. And it could be a limited or narrow scope or a very broad scope. And so an example of a narrow scope power of attorney might be for real estate transactions. Bob and Shirley own a home in Florida. They don't go anymore. They want to sell it, but they don't want to go down to Florida for the closing. They may give a very narrow or limited power of attorney to their realtor to sign documents on their behalf at the closing. So that's very narrow in its scope, specific just to that real estate transaction. I'm generally, for clients, looking at, what are their needs? Where are they at in their life? What might we need to be able to do for them if they couldn't manage their assets on their own, whether it's effective immediately or not? What types of assets do they have? How old are they? And I might be looking at a very broad power of attorney. And that's where we're looking at Medicaid. Medicaid usually requires us to have a very broad scope power of attorney. We want the ability to maybe make gifts, to be able to create trust, to be able to transfer assets to others, because we might need to be able to do that for Medicaid purposes. And so what I'm looking for is, for example, if Bob needed long-term care and we were going to apply for a Medicaid benefit, if he had assets that were just in his name, that would be over the amount that are allowed to be titled in his name, or he had a life insurance policy that had a cash surrender value that was too high, we're going to need authority to be able to transfer those assets, to maybe liquidate them, to be able to transfer them, maybe place them in trust, maybe make gifts to a spouse or gifts to family members. And if our power of attorney doesn't have those provisions in it, we're not going to be able to do that. We have no authority. And it might prevent us from being able to apply for Medicaid. And we may have to then go to court, maybe have a conservator appointed and ask the court for some very specific powers under that conservatorship to allow us to create that Medicaid application. And depending on the circumstances, the court may or may not grant us the authority to do that. And so looking at your power of attorney in advance, understanding when it becomes effective and understanding the scope of power that you've given, and knowing what powers you may need in the future, even if you don't need them now. It's very important to work with an attorney. I would be remiss if I didn't mention that Michigan did recently, in 2025, it came into effect, the new Uniform Power of Attorney Act in Michigan. And why I bring this up is because that new statute within the body of the statute actually creates a form. We call it a statutory form. It's a form of a power of attorney. And I have seen that there are some banks that are printing off a version of this form and giving it to clients who may come in. And my concern with that power of attorney is, first of all, in the statute, it has several areas where it advises the person to talk with an attorney. And I'm, just the cynical part of me is saying probably if someone's giving you this document, you're not taking it to an attorney to review, you're just filling it out. And there are a lot of check boxes on there. And there are ordinary powers and there are extraordinary powers. And the powers that sometimes we need for Medicaid are in that extraordinary section. And a person may be just looking at that document and seeing, oh, create trusts or create gifts or give gifts, may be a little bit concerned and not understanding how that might come into play for Medicaid purposes specifically, and may not check those powers, and that could ultimately come back to be a problem for them. So durable powers of attorney are very, very powerful tools and very important tools in our toolbox, especially as we age, and in particular if Medicaid is on the table, or any long-term care planning for that matter. And so I encourage everyone to have one of these documents. I encourage you to understand what is in your document. If it's been several years since you've had one, I would encourage you to look at that to see if it needs to be revised or updated, because we all want to be prepared. Thanks for joining me today. I look forward to seeing you at the next Medicaid moment.